Bring in Andy McCarthy, former federal prosecutor, former assistant U.S. attorney, and Fox News contributor.
Morning.
Andy, the president seemed really upbeat about what took place yesterday in the courtroom. Did he have a reason to be? And what is the greatest area of concern for the defense team?
Well, I think he did have reason to be because prosecutors generally want to start very strong. And the witness that Bragg seems to have put on, Alvin Bragg, the elected Democratic district attorney of Manhattan, is David Pecker, a longtime friend of President Trump's, who clearly was not hostile to President Trump. And I think given the Trump team's understanding of the case, what they realize is that while there seems to be a lot of evidence being offered, it's evidence of conduct that's actually legal. So he can't have thought that that was a bad day for him. On the other hand, you ask me, what is the biggest defense fear? You know, it's one thing to be watching the trial through the media. If you're watching it on our channel, you hear me, you hear Kerry Kupek, you hear Jonathan Turley talk about the weaknesses of the case. The jury is not getting that filter. The jury is getting the district attorney's version of events and taking its cues from a judge who's been very friendly to the district attorney. So if you're watching this with legal commentary, you know that they're not really proving a conspiracy in there, and you don't really have a federal campaign finance violation in there. But I don't know that the jury knows that.
So, Andy, I was stunned when I looked at the testimony and the cross that was happening. And typically lawyers, especially the prosecutor's office, go through the testimony. But it seems like they weren't prepared for Pecker to say that he's done this for other clients. You know, they kind of make this case as if it's unprecedented that Donald Trump is the only one that did something like this. Were you surprised by that?
Yeah, I'm always surprised when experienced trial lawyers, whether they're prosecutors or litigators who work the other side, what you have to, when you're putting an important witness on, as they say in the biz, draw the sting of any bad testimony. You don't want to have a situation where you draw the story out of a witness and then you turn them over for cross-examination, and then the jury starts to hear the bad stuff because then they think you're trying to hide the ball. So, you know, ordinarily prosecutors make a point of eliciting from their witnesses all of their prior bad conduct or any of their credibility problems. So at least the jury thinks you're playing straight with the jury. And I think here they may have been a little bit surprised by some of what they heard.
Andy, you said that so far you don't feel like they're doing a good job proving that there was a conspiracy. You're not sure how the jury will feel, but the jury has two lawyers. Do you think that they're thinking the same way you are?
It's hard to say unless you know the lawyers, Ainsley. You know, the only way they would have gotten on the jury is if they satisfied the parties that they can decide the case based solely on the evidence that they hear in the courtroom. And this is important, the judge's instructions that the judge will give the jury at the end of the trial, which will be critical. So again, one of the things I'd be very concerned about as the Trump team is so far Judge Merchan has gone down the line on almost every important issue, ruling in Bragg's favor. And I would expect that the jury instructions that he gives at the end of the case will be favorable to the prosecution.
Andy, last question on this trial. We saw the clip there moments ago from the former president emerging from the courtroom yesterday, and he said this is a case that should have never been filed. And viewers might say, well, of course he would say that. He's Donald Trump. He's the one on trial. But I think it's worth pointing out, if I'm not mistaken, the feds looked at these exact same facts and decided not to pursue a case against Trump criminally. And the predecessor to Alvin Bragg did the same here in New York City, came to the same conclusion. So there are some people in important shoes who actually agree with the former president on this key legal point, right?
Yeah, that's exactly right. This case started in my old office, the U.S. Attorney's Office for the Southern District of New York. They looked at it, decided not to bring it. Cy Vance, who, as you mentioned, is Bragg's predecessor, looked at it, decided not to bring it. Bragg himself shut it down in 2022 before reviving it. And one other thing I think that's very important here that's being missed, because it's like the dog that doesn't bark. The federal government, the Justice Department and the Federal Election Commission have exclusive authority in the United States to enforce federal campaign finance law. If this was any other state or municipal prosecutor in the United States trying to enforce federal law, they would be papering the state courts and the federal courts with all kinds of motions to try to prevent a district attorney from usurping federal power. That's not being done here because it's Bragg and it's Trump.
For us non-lawyers, I found that the arguments fascinating yesterday at the Supreme Court as we try to find out what level of immunity any president has, not just this one, not just this case. It was kind of a high-level debate. In the end, I don't know how many people were converted, Andy, but what did you pull out of that, of some of the exchanges with all the Supreme Court justices and both sides that you think is going to figure in the decision?
Brian, I think the most important concession was by Michael Dreeben, who was the lawyer for Jack Smith and for the Biden Justice Department, who basically conceded that there is presidential immunity from prosecution. Now, he doesn't allow that it's as robust as President Trump argues, but he certainly made a concession to the court that there is an ambit of executive authority that Congress can't criminalize. So once you make the concession that there is some measure of presidential immunity, then the question becomes, what acts does it cover? So I think by the end of the argument, it became, at least to my mind, much more likely that the court may resolve this by sending the case back to Judge Chutkan, the trial judge in Washington, with instructions to go through the indictment and sort out what is a official act of the presidency and what is a private act that isn't covered by immunity. If that's what the court does, I don't see how this case gets to trial prior to Election Day.
What happens when they do send it to that lower court? What do you know about this judge?
Well, so far she's been very hostile to Trump. She's ruled Smith's way on almost everything. But you know, Ainsley, judges behave better when they know someone's checking their work. So this is an immunity issue. It's going to be reviewed by the D.C. Circuit, and it will ultimately, because it can be appealed pre-trial, it could go right back to the Supreme Court. When you know someone's going to be scrutinizing your work, you tend to do a better job.
So, okay, we're going to get it one way or another. We're going to get something by June?
Oh, yeah, I think for sure the court will decide this part of it. I think if they decide to send it back to Judge Chutkan, that may happen even faster than June.
So why would it take Judge Chutkan a long time to come up with, to separate the case?
Because it's not always easy, Brian, to say something is an official act or an unofficial act. Like, say, if a president is giving a campaign speech, that seems to be an unofficial act, right? But in the middle of the speech, he says, and that's why I'm removing the Secretary of State and appointing a new one. Then it becomes an official act, right? Because that's a presidential act. So she may have to have hearings on all the different allegations in the indictment and hear evidence from both sides about why they say it's an official versus a non-official act. That could take a lot of sorting out, and then it gets appealed.
Yeah. It just seems like it's going to be difficult if they, instead of giving blanket immunity, if you bring it down to what is official and what's non-official, then all of the president's actions is constantly going to be going back to the court. If we politicize the court in this way, right?
Yeah, but I think, Lawrence, the problem there is it's not a legal problem. That's a really sort of a cultural and political problem. I mean, we went almost a quarter of a millennium without this happening. President Trump constantly says, a president has to have immunity. Well, we went 220-something years without a court having to say that because it was obvious enough to everybody who operated in the system that you can't have a president making important decisions worrying about whether his successor is going to use the Justice Department against him. That's a brand new brand of poisonous politics that's really modern. So I'm not so sure that's a legal problem as it's a political problem and a cultural problem in this country, that people think that's okay to do with your government authority.
He's great in the evening on the primetime shows, and he's sensational for the morning shows. Yeah. What can't Andy McCarthy do?
Nothing.
Thanks, Andy.
Thank you.
Great job.
Thanks, guys.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.